JJ. So this is my presentation. I listened to Commissioner Ivy, and probably I can choose to forgo my presentation and just go with the question and answer. But then, sayang rin naman to. This is, first of all, I'd like to thank you for inviting me here and presenting. I heard that there are about 300 or more registrants. I wish to thank all my relatives for registering this afternoon. Anyway, my emphasis for today in telemedicine is that ethical and other legal issues. I'm Dr. Macalino. So this is the outline of the presentation. Of course, this was defined already by Dr. Ivy. And in the College of Law, we say laying the predicate, is it the practice of medicine? That has been answered already, confidentiality and duty of care. Medical negligence may be the one of the more important things in telemedicine. And then we go into special problems, meaning recording and e-prescription. And then the conclusion or the final words. The World Health Organization has defined telemedicine as delivery of healthcare, where distance is a critical factor. It uses information and communication technologies in the treatment and prevention of diseases. Well, the second definition was the continuing education of healthcare providers, actually. So some would say that that first aspect of this definition may be telemedicine, and the second aspect is that of telehealth. But then I reckon that telehealth is a broader thing, but then most of other people would consider telemedicine and telehealth as this one and the same thing. So we go to the Medical Act of 1959. Telemedicine, is it the practice? Is it a practice of medicine? Well, Section 10 of the Medical Act of 1959, subsection A, would define practice of medicine as physically examining any person to diagnose, treat, operate, and prescribe remedy. However, Section B or subsection B would define, again, the practice of medicine as through radio, television, and any other means of communication to diagnose, treat, operate, and prescribe remedies. The first subsection A, is the traditional, and probably because of that or any other means that would encompass telemedicine. Wait. Yani naghang. Hello. Sorry for that.
No problem.
Okay.
There you go.
Okay. The second definition, B, is one that actually defines telemedicine. Can you imagine that? In 1959, they did not know that they are already defining the practice of medicine or telemedicine as a practice of medicine. But then, can telemedicine be also subject to illegal practice of medicine? Of course, when you're not a doctor, that's immediately an illegal practice of medicine if you don't have your certificate of registration, or if you did not renew your license, that can be illegal practice of medicine. This was also referred to by Dr. Patdu, DOH NPC, the National Privacy Commission Memorandum Circular 2020-03, wherein they define actually telemedicine, the practice of medicine using electronic and telecommunications technology for the delivery of healthcare at a distance. So if it is practice of medicine, then it is subject to confidentiality, physician-patient relationship, and even duty of care. This is Section 24 of Rule 130 of the Revised Rules on Evidence, disqualification by reason of privileged communication. Well, the relationship between the physician and the patient is privileged. The physician cannot, in any civil case, without the consent of the patient, be examined as to any confidential communication made for purposes of diagnosis and treatment. Some would say that the communication is privilege as defined in the case of Chan versus Chan, because, or for the reason that it should encourage the patient to open up to his or her physician so that the physician can make a correct diagnosis as to the ailment and provide adequate or appropriate cure. This was also referred to the Lucas versus Tuano case in 2009 and talks about the duty of care of the physician. Every physician in treating his patient is under a duty of care, which means he should exercise the degree of care, skill, and diligence which a physician in the same general neighborhood and same general line of practice is supposed to or ordinarily should possess or exercise. Now, these are the physician's breach of duty of care may give rise to these liabilities. Now, these are the basis of medical malpractice, at least in the Philippines. You have administrative liability, which means either the PMA Code of Ethics or sometimes in every professional organization of doctors in the Philippines, each professional organization would have a code of conduct. So violations of that code of conduct and the PMA Code of Ethics would give rise to administrative liabilities. Under civil liabilities, you have violations of 2176 and violations of 19, 20, and 21. These are the civil code provisions on human relations. And of course, you have criminal liability under Article 365 of the revised penal code. And of course, right now we have, since 2012, we have violations of the Data Privacy Act. Each of this breach of duty would constitute medical malpractice and or negligence. Now, most of the ethical aspects are under that administrative, under A, ethical aspects in the practice of medicine. The legal basis of medical malpractice, again, in Medical Act of 1959, you have Section 24, which is the grounds for reprimand, suspending, and revoking the certificate of registration. Under subsection 2, that's immoral or dishonorable conduct. Subsection 5, gross negligence and ignorance or incompetence. And under subsection 12, that's code of ethics or violation of the code of ethics of the Philippine Medical Association. Now, as to that code of ethics, in the code of ethics itself, it mentions unethical practice and unprofessional conduct. Here it is. Now, this is the PMA Code of Ethics implementing guidelines. The Philippine Medical Act of 1959 Code of Ethics issued by the Philippine Medical Association should be complied with by all physicians, whether they are members or not of the Philippine Medical Association. They are violations of such may constitute unethical practice and unprofessional conduct. They are, or they can be grounds for reprimand, suspension, and again, that thing regarding expulsion. So some would say, how can you be expelled when you are not a member anymore? Well, renewal of the membership to the Philippine Medical Association entitles you to a lot of things. First is to join or to be a member of the PhilHealth as a provider. And you cannot renew actually your medical license if you are not a member of the Philippine Medical Association. This is the PMA Code of Ethics. And Article 2 is actually about the duties of the physician towards the patient. It has several more articles there, as shown in the left-hand side of the screen. However, what is most important here is Section 5 and Section 6, which actually lists down all the ethical violations of a doctor. What is important here is actually the informed consent. No, a physician shall obtain from the patient an informed consent. It seems to be a mandatory provision So this becomes important in telemedicine. And under Section 6, the physician should hold sacred and highly confidential whatever he discovers or what be discovered during this telemedicine in our practice. This is a sample of the PMA consent form for telemedicine. Again, what Dr. Ivy told you is that there are a lot of sample forms. The PGH has one, each hospital may have one, but then the most important thing are the provisions of this informed consent. So the potential risk, look at the risk there. I understand that there are potential risks for using technology, and this is with reference to telemedicine. The data privacy and confidentiality of the consult. The limitations of the consult, basically this is in reference to the signal, the computer, and audibility, and the likes. And of course, the rights of the patient. The patient has the right to ask a non-medical staff to leave the telemedicine conference room, to terminate the telemedicine consultation and the physician-patient relationship anytime, to obtain copy of the information obtained and recorded, and to be assisted by a family member or a caregiver. And lastly, in case of urgent concern, that he or she may be directed to obviate or to stop the telemedicine conference and be at the emergency room of any hospital. Of course, the civil aspect of medical malpractice is under 2176 of the Civil Code, which would read, whoever by act of or omission causes damage to another, there being fault or negligence, is obliged to pay for the damages done. This is in relation to 1157, which actually states that obligations may be from that one quasi-delict. But then in 2014, in the case of Alano versus Logmao, actually it is in the concurring decision of Mr. Justice Leonen. He said that we can use Chapter 2 on human relations. That is Article 19, 20, and 21. Let me read them for you. Every person must, in the exercise of his right and in the performance of his duty, act with justice, give everyone his due, and observe honesty and good faith. I reckon that if you will be using human relations, you must be, or you should be using Article 19 together with Article 20 or together with 21. Why? Because it is in keeping with 2176 because of the phrase shall indemnify. And let me read it again for you. Every person who, contrary to law, willfully or negligently causes damage to another shall indemnify the same. And for Article 21, shall compensate. Any person who willfully causes loss or injury to another in a manner that is contrary to moral, good customs, policy, shall compensate the latter for the damage. Again, looking back at Article 19, walang bayad po dyan, no? As opposed to 2176, wherein that person is obliged to pay. So again, take home message, use Article 19 or do not use it at all. Use 20 or 21. This is the chapter, the sole chapter on criminal negligence under Article 365. You know, that's very difficult to memorize. But then in law, we are mandated to memorize at least the elements. These are the elements of reckless imprudence. In order to be liable of criminal negligence, you should have the elements of reckless imprudence. That offender does or fails to do an act, that the failure to do an act is voluntary, it's without malice, material damage resulted, and that one, inexcusable lack of precaution. In the vernacular, what is that? That is called walang patunggaling pagwawalang bahala. Now, that is very difficult to prove. If you are a doctor, medyo lamang ka na dyan. Mahirap i-prove po yung inexcusable lack of precaution. Now, this was also cited by Dr. Patdu. How do you prove duty of care? How do you prove that? Well, first is to prove that by learned treatise, yung mga libro, yung mga journals, no, learned treatise. But then the most common way to prove that is actually through an expert testimony. Well, the problem with expert testimony, not all will be treated as an expert. So as an expert witness, you have to show that to show the standard of care that the defendant was bound to follow the standard of care, and he fell below or she fell below the conduct of the standard of care, below that standard, and that falling below such standard or not practicing such standard of care caused the injury. So yun lang ang kailangan natin i-prove. But then again, that is difficult to prove. First, you will be questioned as to your qualification of your expert witness giving his expert testimony and giving the standard of care. Of course, we have to establish the negligence, or sometimes when you are to establish the negligence in telemedicine, the complainant, if you are a complainant, he must present the testimony of an expert witness. Again, there are a lot of jurisprudence regarding this. Usually, he should be in the same line of the person who did not follow standard of care. Like, for example, if I'm a surgeon and I'm a member or a fellow of the Philippine College of Surgeons, you have to present somebody who is also a surgeon and a fellow of the PCS. Hindi po pwede nagtutuli lang talaga dyan, but then he should have the proper training as that of a fellow of the Philippine College of Surgeons. The proof of breach alone is not sufficient negligence. There should be causal connection between the breach, that he did not follow standard of care, and the resulting injury. Again, the negligence must be the proximate cause of the injury. So, if a telemedicine physician's breach of duty or standard of care, it should be, again, the proximate cause. The physician may be held liable for the injury, but then we have to look at the limitations of technology. Possibility that information provided by the patient may have been incorrect or at least lacking. So, temper muna natin ang mga problems with telemedicine as of the moment. Under Republic Act 420 of the Wiretapping Act, it is unlawful. Can a telemedicine practitioner record the consultation? Just like what we are doing here, at least it has to be authorized by all people. Diba? Thus, a consent is a must. Consent from the patient and consent from the doctor before you can record a telemedicine conference. Regarding electronic prescription, well, electronic prescription is an optical data of a captured image, maybe PDF, JPEG, or photo file format, issued by or made by a licensed physician. It can be generated, sent, received, and through email, any email messaging applications. And then this electronic prescription can be honored by the pharmacist in the drugstore or pharmacy. It also includes the digital signature, the name, and the license number of the physician, his or her physician, PTR, and he should keep a copy of the electronic prescription in the patient's compilation of medical records. Regarding electronic document, as opposed to as defined by Electronic Commerce Act of 2020, even that prescription is an electronic document. It shall have the legal validity and enforceability of any other document or legal writing. So, to end this mini lecture, this time is still the time of pandemic, which enhances the need to innovate the delivery of medical support, diagnosis, treatment, and this is actually through telemedicine. Telemedicine is a practice of medicine. Thus, it is subject to ethics, confidentiality, and even duty of care. Regulations applicable to telemedicine are existent, but then here in the Philippines, it's rather new, at least at this time, but then it has its roots in 1994 or 1993 with the establishment of the Telehealth Center of the UP. Since it's new, gaps in the practice of telemedicine still exist. And then, of course, the informed consent on the limitations of telemedicine and all other things provided should accomplish or should be accomplished prior to telemedicine. Thank you very much, JJ. Thank you very much, everybody. Thank you very much, Ivy.